Hello. Yeah, I was a little shocked. I didn't think that he was going to get that much time, but he could have gotten sentenced to anything up to 5 years. So that was that was the judge's prerogative. I was thinking it was going to be more in the 1 year to 2 year time frame.
Do you think he was right to plead guilty? Do you think he should have fought this?
This was the problem of why he pled guilty was we'd been told all along from St. Catherine's that a breaking didn't occur. And then the day of trial, the officers had changed their testimony and said a breaking had occurred. And that was what changed our decision from going forward on all 3 charges to just plead guilty to this 1 charge.
I know that his wife leaving the courtroom the other day just briefly mentioned she felt like it was the better end of the deal. Because you guys didn't know what would have happened had it been left up to that jury.
And that's what happens is he was looking at 55 years. Okay. And the charge that the charges that he had was the burglary charges. What he pled to here was a conspiracy, which was the harder charge because it's basically individuals getting together to sort of plan to do something. And that would have been what we always felt was our hardest part because everything was on Facebook. Everything had been talked about between the parties about going and getting the photo and going to St. Catherine's. All that stuff was out on Facebook. We had always felt real comfortable that a breaking hadn't occurred, and when that changed, and then we had people saying that a breaking had occurred, that's what basically changed our position on what we needed to do and why he decided to plead guilty to the conspiracy charge.
So did you have a number of months in mind that you thought it was going to be?
I mean, we knew he was going to get 5 years, okay? Because what happens is on a charge like this, they're going to give you 5 years, and then they're going to give you a date to release after you serve so much time. In his situation, he's not going to serve even on the 2 years, 6 months. He's not going to serve the 2 years, 6 months. So it's going to be considerably less than that. What starts happening is when you get a sentence of the 1 to 2 year range, they start it all becomes the same. You're going to serve the same amount of time, whether it's 1 year, 2 year, 2 years, 6 months. There's not a big difference of what you'll actually serve. And that may have been part of what the judge was, I guess, contemplating when he made the sentences. It didn't really matter as far as the actual amount of time that he sentenced him to.
So with the remorsefulness, that did kind of help him.
I think so, and this is one thing that I think that needs to be said. That happened the day that he was arrested. He came out and said everything, what happened, gave him his passwords, did everything that he was supposed to, when he was initially being, I guess, interrogated by the officers. So he didn't have anything to hide, and he was always forthcoming with this. And I think that did help him out as far as his sentence goes.
Will he be eligible for the 25% for nonviolent?
I believe that's how it's going to work. This is one thing that anytime you're dealing with MDSC, everything changes. And you don't want to tell your clients you're eligible for this, you're not eligible for that, because as soon as you tell them this is what you're looking at, MDSC changes how they look at everything, and then your client either does a lot more or does a lot less, which causes problems for us because then we didn't give them the correct information. So we've looked at it. We feel that he's going to serve less time than that 2.5 years, but I just hate to say he's eligible or not because they keep changing their policies all the time.
It appears John Murray was the mastermind of this. Do you feel any bitterness, or do you think that he wasn't treated fairly because he didn't get any jail time? He was non-adjudicated while your client was.
I mean, I understand the rationale behind it because what it came out is Clayton had a prior felony charge, which it was going to be eligible to be expunged in a couple months, but it's still on his record at this point, and that's why he got the sentence that he got. It was actually out there at that time. He wasn't eligible for the non-adjudication or the pretrial.
What was that previous felony charge?
It was, I think he pled to a possession charge out of Rankin County.
Marijuana?
Marijuana, I think is what it was.
So with him being in the act of versus pre-planning with the other guys, so this was more of a sentencing. Like
Yeah.
since he was doing the actual.
Well, what was happening, what was interesting to look at when you got into the Facebook messages and what the DA's office did, and this is one thing that they did a very good job of. They went back and they were able to piece together not only what like John Mary was saying to Clayton, but what he was saying to the other people after he'd get off the phone with Clayton. And that's how they sort of pieced together who was actually sort of driving the bus in this situation. Clayton was a guy that they were getting to go, they were sort of egging him on to go in and get the photo, but it was actually these other individuals that were really pushing it sort of in the background is what all the Facebook stuff really started showing. And I think there were some other individuals that were actually, they were talking to during this time also.
So
I know the prosecution has said they don't think the McDaniel campaign profit was involved. What do you think?
I don't think it was ever. I think you had some guys that were definitely McDaniel supporters. I don't think that it ever showed that there was anything that the campaign itself was doing that. Now, whether or not John Mary or some of those others, the other individuals that pled guilty, whether or not they had talked to them or had communication with the campaign, we never saw anything of that nature. And I can tell you, Clayton didn't. Clayton's was always on the peripheral of that. He never had the direct. I think he had met McDaniel like in some function, but that was the extent of any connection to the campaign as far as Clayton went. Now the other individuals I think knew some of these people more on a personal level.
So you think your client's downfall was just his desire to make a name for himself that overrode his better judgment?
I think that's what, I think it was a stupid decision on his part that at different times, I think people told him that, the story that he was doing ended up being correct. However, being journalists, you don't do stuff like that. I think the judge was also right that journalists, that are performing their function in a proper manner would not have done what he did. And I think he sort of being naive to, the political process, and also he's not a professionally trained journalist. I think that he crossed some bounds that if he had, been trained in those areas, he probably wouldn't have done it. No, but it's over, and I think we can finally put this to bed, hopefully.
Thank you.
Thanks, Kevin.